Brussels Report podcast.
Welcome to the fourth edition already of the Brussels Report podcast. I'm more than happy. My name is Pieter Cleppe. I'm the editor of Brussels Report, and I'm more than happy to have as my guest today Carl Baudenbacher, I should say Professor Carl Baudenbacher, who's a Swiss national. He's a Swiss legal expert, a senior legal expert, I should say, who has been a professor or is a professor at various universities, University of St. Gallen including, and also University of Texas at Austin School of Law. Most notably, perhaps, for many years, he has served as a judge at the EFTA Court, and he has even been the president of the EFTA Court. And at the moment, he is serving as an independent consultant and also an arbitrator, and he's a senior partner at a Swiss law firm in Zurich. Perhaps I should clarify what the EFTA Court is. I think most listeners will probably know this, but the EFTA Court, unlike the name may suggest, is the court of three of the four EFTA countries, those EFTA member states that are a member of the EU's single market, so to speak. Those are Norway, Liechtenstein, and Iceland. Switzerland is not subject to this supranational court. We can talk about this further. I understand, Professor Baudenbacher, that you were serving on that court in representation of Liechtenstein. Is that correct?
Yes, thank you very much, Peter. Thank you. I'm happy to be here. Yes, I was nominated by the Principality of Liechtenstein in 1995. There is no nationality requirement. During the EEA negotiations, I had served as probably the most important advisor to the government of Liechtenstein. And then when they finally joined, they asked me whether I would like to become their judge.
Very good, very good. And of course, me as someone who has been dealing a lot with Brexit, we had to look a lot into, when I was with Open Europe, the British think tank that I was representing in Brussels, then we had to look a lot into the details of the EFTA-EEA arrangement and to what extent that would be attractive or not for the United Kingdom. And then, of course, I came across your analysis and comment very often. So yes, let's maybe go right into it. Alongside Brexit, something seems to have exploded when it comes to the relationship between the EU and Switzerland. So for many years, this has been governed perfectly well by bilateral deals, which I always have called a pick and choose arrangement, whereby the Swiss pick which EU rules they like to follow, and in return they get market access on that area. However, for I think 10 years now, the European Union is trying to change that relationship and is particularly trying to impose not the EFTA Court, but the European Court of Justice, so its own top court as the supposed neutral arbiter in this EU-Swiss relationship. I think it's fair to say that for a long time the Swiss have been waiting what would happen with Brexit, so to see then how they could position themselves. Brexit has happened. The top EU court, the European Court of Justice, has almost no role in the EU-UK relationship. So what is the way forward now? What do you think? Will the Swiss government now be bold enough to say, sorry, we don't want this proposed relationship or this proposed update to the relationship? Or will they do something else?
Yes. Well, let me probably first say this. I also used to tease my own home country, as cherry pickers for a number of years. But, in the meantime, I have started to have second thoughts. And in politics, it's like in business. You don't get what you deserve, but what you bargain. And the Swiss has so far have bargained fairly well. but nevertheless, they had to swallow at least one or two bilateral treaties which they didn't want to. One is the Free Movement of Persons Agreement, and the other one is the Land Transport Agreement, which guarantees the European Union operators access to Italy. If you look at European geography, then you understand what I mean. And the Swiss have made huge investments into this Transalpine basic tunnel, railway basic tunnel, way more than 20 billion euros. So at the end of the day, I think you cannot call them cherry pickers anymore. Now, to the current situation, EU-Switzerland, yes, these negotiations concerning the conclusion of a so-called framework agreement, which would frame the existing bilateral agreements, or the most important ones, have been going on since 2014. And now it seems that the agreement is virtually dead, because there have been a couple of stumble stones in the last 2 years. They were more or less discovered, and it seems that the parties cannot agree on those. However, as you allege, Peter, the real problem is, the institutional problem, that the Swiss government has, in the course of the negotiations, agreed to give the court of the other side, namely the Court of Justice of the European Union, the decisive say, and at the same time, the Commission, is factually the surveillance authority of Switzerland. And this touches upon fundamental sovereignty concerns. And for years, this has not been discussed, but in the last 2 years, there have been civil society organizations, business organizations, mushrooming almost in the country, discussing this issue. And now it looks as if the agreement would not be signed.
And will the Swiss government just tell the EU side, look, friends, we know we negotiated that, but we were wrong to think it would be accepted. Let's renegotiate, or what else would they do?
Well, that is quite open for the time being. There are those who say, let's stop now and let's, agree ourselves in Switzerland what we want to have and take a break. And there are others who say, well, if we have to stop, then let's leave the draft agreement on the table and negotiate along the lines on which this draft agreement is based. I think the second option is suboptimal. I mean, if we have negotiated for 7 years and it hasn't worked out, you should stop and try to go back to the start.
What would you think would be the ideal relationship between the European Union and Switzerland?
Well, I mean, interestingly, in 2013, the Union proposed to Switzerland to dock to the EFTA Court. That would have meant that Switzerland wouldn't have had to swallow the whole single market acquis. They could have kept their sectoral approach, but as far as these individual bilateral treaties are concerned, they would have accepted the jurisdiction of the EFTA Court, and they could have negotiated the right to have a judge on the EFTA Court in these cases. The Swiss government rejected this offer. It was a very generous offer by the European Union, and I'm quite firm on this. It's obvious that the Swiss government tried to smuggle Switzerland into the European Union through the back door by accepting the Commission and the ECJ at the time. And in the meantime, the government does not openly admit that they made this mistake, but there are more and more people who say, I mean, who on earth is agreeing to the jurisdiction of the court of the other side? That may function in the case of former Soviet republics or former colonies in Northern Africa, but not even that is sure. But how should an old democracy and successful economy like Switzerland accept this?
Exactly, that's a point I've always been making myself as well. And indeed, docking would mean that the Swiss would have, indeed, as you mentioned, a judge on the EFTA Court for issues relating to the areas where Switzerland has pledged to to comply with EU regulation. Do you think there's any chance that the EU will say, okay, let's return to this offer that we made?
Well, I cannot say that, but I know that in 2018, in early 2018, the EU or Mr. Barnier has made this offer to the Brits. And I mean, if the European Union wants to keep Switzerland at least partly integrated in the single market, they will have to offer something else than the ECJ. And then I cannot see anything else than the EFTA Court, because a bilateral court is not feasible. So I cannot tell whether the Union will agree to this, but if they do not, they risk that Switzerland will go the same way as Great Britain. That means to leave the single market. That means no adoption of EU law, no supranational surveillance, no supranational judicial control, and a retreat to a mere free trade model. This you could then call a Swexit at the end of the day. This, you know, a lot of people fear this in Switzerland. There are others who say, well, you know, we could arrange ourselves and we would find solutions. And growth is happening outside of Europe anyway these days, and Switzerland is strong in the Asian markets. I cannot tell, you know, how this would develop, but one thing is sure, in my view, it would also be bad news for the further cohesion of the European Union if they would lose Switzerland, which has been a partial member of the single market so far.
Yes, because the actual effect would be that Swiss EU trade would be a lot more restricted than today.
Yes, probably yes. Although, I mean, there are also now people who say it depends. A lot of trade depends on certification of certain machinery, and the certification could be done in Switzerland. It could also be done in the European Union. Exports would become a little bit more expensive, but it would not really affect the trade between Switzerland and the European Union. Nevertheless, politically, it wouldn't be a good sign for both sides, I think.
Well, but in a way, we now have, of course, the UK, let's say, serving as a guinea pig for that, because now we can see to what extent the new restrictions on EU-UK trade will, in practice, also hurt trade. I mean, what is your idea about the Brexit deal, and to what extent it will indeed, let's say, hurt trade flows between Britain and mainland Europe?
Yes. I mean, first of all, I think Switzerland is in a different situation than the UK. I mean, they have this network of existing bilateral treaties. Okay, the Union has been threatening not to update them anymore if the Swiss don't swallow the ECJ. But that remains to be seen, whether these threats will become real. At the end of the day, Switzerland is located in the heart of Europe, and, you know, there are a couple of 100,000 commuters coming every day. And Switzerland is more integrated in the European market than probably most of the member states. As far as Brexit is concerned, I was never a friend of a hard Brexit. You know, after the Brexit vote in June of 2016, I was invited to give speeches on all sorts of media, and I gave lectures in all UK constituent states and in Ireland. My message was always, if you want to leave the Union and become politically independent, and also become independent with regard to trade with countries outside of Europe, then you left now, but it would be good for you to go for a soft Brexit and to stay in the single market. And also, when I was invited to testify before committees of both houses, that was my message. This initiative failed, as we know. At the end of the day, it was a closed vote in the House of Commons, I think in June of 2019. And now the UK is out and is in a difficult situation as far as trading goods is concerned, if I feel correct.
Yes, and of course we'll have to see the actual effects. But of course, also there, some people are saying, well, the rest of the world is booming, and and a lot of trade is actually not happening in a context of dependency of treaty provisions. I mean, personally, I think the one thing should not exclude the other. It's not because you have great opportunities outside of treaty, arrangements that you should sacrifice existing opportunities offered by, FTAs and treaty arrangements. Well, let's maybe move to the next subject, which I definitely wanted to discuss with you, and that is to what extent the European Court of Justice in Luxembourg can be accused of judicial activism, because apart from the reason that the UK and Switzerland are not happy to subject themselves to the ECJ in Luxembourg because it's a top court of a foreign jurisdiction, they are definitely also wary of the reputation of that court of reinterpreting treaty provisions to basically enable more transfers of power to the EU level. At least that is what the Eurosceptics have always been saying. But not only the Eurosceptics, we have seen, of course, since the 90s at least, the German Constitutional Court and the judges of the German Constitutional Court being not very cooperative at times when it comes to going along with the logic of the European Court of Justice. And recently we see that perhaps in a different way, but also in other member states, we have some challenges in this regard. Notably, there is this, you could say, dispute between the Polish top court and the ECJ, or at least the Polish sovereign order. But also in France, we recently have now seen the French government and the Conseil d'État, if I'm not mistaken, a top French court in any case, being very wary to accept ECJ jurisdiction when it comes to data retention. So what is your opinion on that? Is it fair to say the ECJ has in the past really been going too far when it comes to judicial activism? And secondly, is there a risk that perhaps that countries or jurisdictions, national jurisdictions, will no longer comply with the superiority of EU law, which would ultimately be a danger to the EU single market?
Yes. Well, I mean, that's a little bit a difficult question for me, because I have been accused of being a judicial activist myself while I was the president of the EFTA Court, in particular by Norwegian government circles.
Yes, I saw that you have been called King Carl of the EEA, as one of Norway's most powerful men.
Yes, they did that, and I always said, well, thank you for this nobilization. In any case, I think that, the accusation that a court is a judicial activist is as such an empty formula. The decisive point, in my view, is whether the court is able to make its constituencies accept any new step. I mean, no court will stick, to the so-called original meaning. It's even difficult to find out what the original meaning is. And if you look at, for instance, what has been going on in the United States, sometimes justices of the Supreme Court were appointed by conservative presidents, and then they moved to the liberal wing of the court. William Brennan is probably the most famous example, but also the current Chief Justice John Roberts, who was a George W. Bush appointee, has voted with the liberals to uphold Obamacare, this act which aims at providing affordable health insurance for all Americans. So my point would be, the question is a court going so far that its constituencies don't follow anymore. And in the case of the ECJ, I would distinguish between, let's say now, the situation in Germany or in France. In Germany with the Bundesverfassungsgericht, where we had these reservations for a number of years. And now we see that the Bundesverfassungsgericht is not quite happy with certain judgments concerning the stabilization of the European single currency. In France, we have this judgment now of the Conseil d'État concerning, the data. I think these Supreme Courts do not challenge the ECJ as such, or Constitutional Court. They challenge ECJ case law in certain fields. Whereas what's going on in Poland is quite different. I think that is really an attempt, to cut back the power of the ECJ in a comprehensive way. And that remains to be seen, how the European Union can deal with this. This is dangerous. Also, what's going on in Hungary is dangerous. I think that the relationship between the ECJ and the French high courts, as well as the German Constitutional Court, that can be sorted out in a judicial dialogue. I mean, at the end of the day, none of these high courts is questioning European integration as such. But in the case of Poland, my feeling is a little bit different. That is going to be very difficult.
Yes, thank you. That's very interesting. Let's maybe move to then the EFTA Court, and I would say the EFTA-EEA or EFTA in general. I mean, one of the ideas on the British side has been for the UK to join this. I mean, I personally think that could still happen in the sense that the United Kingdom could join the department of EFTA that is the non-single market department, which currently only counts Switzerland as its member. And perhaps I've always thought, and maybe this is something I'd like to have your opinion on, that the EFTA-EEA could well be a welcome construct to welcome the so-called Balkan Six. So the six countries in the Western Balkans that are not yet a member of the EU, and where we see concerning influence from China, from Turkey, from Russia. Countries that are becoming demotivated because they are not allowed to join the EU. On the other hand, I think it's absolutely fair that the EU does not allow them. For example, if you look at Serbia, there has been no progress in terms of democratic standards in the last 5 years over there. So I don't think European citizens would like to see Serbia join. But perhaps EFTA-EEA could serve as a framework to sort of make sure that they at least see that they are embedded in the European family in some way. And the United Kingdom, given that it is the only geostrategical player in Europe together with France, really, if the UK would also join EFTA-EEA, then it could perhaps, the whole body could get a more geostrategic nature, and maybe do some good. But please, I'd like to have your opinion on this. Is this incredibly naive, or is this completely dysfunctional, or is it actually a good idea?
Well, I always thought it would be a good idea, to have these 5 countries which are not part of the European Union. That means the 3 in EEA, EFTA, plus Switzerland, plus the UK, in some sort of an association. This could be a counterweight to the European Union, a friendly counterweight, but it would create room for systemic competition. And what I feel has become too strong is this, this desire of Eurocrats, to centralize a lot of policy areas. And so some competition could be quite good. I think that the UK, as well as these 2 Scandinavian countries, and Switzerland and Liechtenstein have certain features in common. They believe in free trade. They believe in a liberal image of man, and so on. So that, in my view, could function. It has not functioned a couple of years ago because there were not enough people going for it. In the UK, the hard Brexiteers said, well, we go for global Britain. I always felt that was a little bit an illusion. And the Remainers said, we are hoping for a second referendum. So they were also lukewarm in that respect. And so that didn't happen. It could still happen, in my view, but with the current Tory government in the UK, it's probably difficult to imagine. In the middle term, I think it would be a very good idea. And I think the European Union should also, now after these 5 years, stop to have bitter feelings with regard to Brexit. Brexit has happened, and they are more or less shooting themselves in the foot if they go on with this attitude, which have this been described by Tagesspiegel, a Berlin daily newspaper in 2016. They wrote that Mr. Schulz and Mr. Juncker are behaving like husbands who have been cheated, and want to take a revenge. I think it would be also in the interest of the European Union if these 5 other countries could join forces to a certain extent. It would also help the EEA, because right now the EEA, the EFTA pillar, is somewhat unbalanced. Norway is more and more playing the role of a superpower, and Norwegian bureaucrats are thinking that they deserve more rights than others, the Icelanders or the Liechtensteiners. So it could strengthen also this EFTA pillar. Now, as far as your question is concerned with the Balkan 6, I may remind you that Madeleine Albright, when she was Secretary of State of President Clinton, she always favored that Turkey should become an EEA contracting party. In my view, it was a mistake to promise Turkey membership at the time. I had an affiliation with Sabancı University in Turkey, and I was there a couple of times and always told people that EFTA and the EEA would be the right thing for them because they should focus on economic integration and not on political integration. And well, the same could be imagined now for the Balkan 6. I think that the Ukraine model, which was proposed to the UK and now is proposed to Switzerland with this fake arbitration panel, which just hides the ECJ, is a form of judicial colonialism that doesn't function. I mean, and people in Brussels should realize this. I was invited to Morocco 2 years ago. I was part of a high-level group advising the Moroccan Foreign Ministry. All the others were EU people. I was the only EFTA or former EFTA man. And I felt that even in these countries of the southern Mediterranean, which are all former colonies of European powers, whether you take now Morocco or Tunisia or Egypt or Jordan, they are more reluctant to accept this Ukraine mechanism than, for instance, the Ukraine or Moldavia or Georgia, because those countries were never colonized in the sense of the word. So I think it would be in the interest of the European Union to move away from this and to open up probably the EEA and to talk seriously to the Norwegians and to talk seriously with the Swiss. In Switzerland, we see now that the government is realizing that in 2013 they made a big blunder when they rejected this docking idea. They don't want to admit it, because politicians don't like to admit mistakes. So they criticize now this institutional agreement for other reasons. But, I mean, the elephant in the room is clearly the ECJ. And, it goes... I'm always reminded, of the 19th century when the Western powers created these extraterritorial courts in China and in Japan. And that caused a lot of bitter feelings. And in China, if you go to China, I've been there many, many times in the last 10 or 12 years, you can feel that until today. And the European Union doesn't need this. Why should they come back, with some neo-colonial thinking vis-a-vis Eastern Europe, vis-a-vis Northern Africa, and vis-a-vis even the UK and Switzerland?
Yes, absolutely. Maybe one more point is if somehow Euroscepticism, so to speak, would strengthen in countries like Denmark or Sweden or even Finland. Today there was a relatively close vote on the EU Recovery Fund in the Finnish Parliament, because what we're seeing is a transfer union being developed in the EU. And at some point, I would imagine that some countries, certainly if they're not a member of the Eurozone, may think, well, why don't we join this alternative, EFTA-EEA, which is there, which works very well for Norway? Or if we want a bit more sovereignty, we go for the Swiss department. I mean, do you think it's in case there would be a vote in these countries to leave, do you think it's politically, or legally easy for them to join, or would there be some obstacles?
Well, I think legally everything can be done if people want to. I always said that when I went on tour in the UK in 2016, 17, 18, and people said, well, but all these legal difficulties. I said, imagine what kind of problems had to be resolved after the First World War, for instance. I mean, if you want to resolve a problem, there are no real legal obstacles. Now, politically, I very well remember that Sweden only voted yes to EU membership by a very narrow margin. It was, I think, 52 against 48%. And it happened after a major banking crisis in the country. Finland at the time wanted to join because they feared, their eastern neighbor. I mean, at the time, the Soviet Union. I think this fear is no more that strong. I cannot speak for these countries. What I see is that in every EU member state, you develop a certain bureaucracy and nomenclatura which loves EU membership because they gain power under the EU constitution, so to speak. The decisions are made in Brussels, and the governments gain power vis-à-vis the people and even vis-à-vis the parliaments. I cannot tell, but I mean, in my view, these are also countries which, from their thinking and even from their religion, EFTA has always been predominantly a Protestant association with Protestant ethics. Even from their way of thinking, they would fit well.
Yes. Well, maybe then one very last question, because you bring up a banking crisis, and you don't have to answer this because it actually relates to, I think, a case that you've been dealing with, which is the Icesafe case. So I mean, I always found this an enormously interesting case. So what happened is you had Icesafe, this Icelandic bank, and you had an EU regulation which basically required EU countries to have a deposit guarantee scheme in case there would not be enough money in the bank, so that the deposit guarantee scheme would then be able to help out. Now, I don't want to maybe go into the details of the case, but if I'm not mistaken, the ruling of the EFTA Court was the EFTA Court had to interpret that EU regulation for the 3 EFTA-EEA countries, including Iceland, was that yes, this EU regulation requires countries like Iceland to have a deposit guarantee fund in case a bank goes bust, but it does not require countries, in this case Iceland, to also make sure that there are enough funds in those deposit guarantee schemes to help out. Is that the correct interpretation of mine, or is it off the ball? I mean, maybe can you tell a bit more about this case and to what extent you're able, of course, to discuss this? and the enormous pressure that must have been there, because it was, this was very important, especially for savers in the Netherlands and in the UK, and then still in an EU member state. And I think many people today look at it as a case very important for what we call the fractional reserve system of banking, whereby banks do not keep all the deposits that they owe to people always in stock, but basically hope that not everyone at the same time will go there to ask for their deposits. It would be very interesting to hear any comment you have on that case.
Yes, well, I remember this case very vividly because I did not only preside, I also was the judge rapporteur. And actually, I think that the EFTA Court made the right decision in this case. Legally speaking, it's absolutely sound reasoning. And politically and economically, we have saved Iceland from state bankruptcy. The Commission tried to drive Iceland into a difficult situation at the time. Iceland was dependent on credits, and the Commission made it sure that Iceland wouldn't get credits from the International Monetary Fund unless they would accept this so-called debt, vis-à-vis the UK and vis-à-vis the Dutch government, because since Iceland, or since the Icelandic Deposit Guarantee Scheme was unable to reimburse the depositors in these two countries, the British and the Dutch government stepped in and compensated them. So it was the governments who wanted to have their money back. And we said, well, there is no legal basis for this. And it was probably also the only judgment of a supranational court in Europe which relied on famous economists, namely on the Nobel laureate Stiglitz, the American, when we said, if we would rule, that in such a case the government must be held liable, we would create a moral hazard. That means we would create wrong incentives, so that people can take irresponsible risks, and at the end of the day, the state is going to pay anyway. I said often in speeches when I came to this Icesafe ruling, I said, well, most lawyers don't even know what a moral hazard is. But I'm a lucky man because my wife has written her PhD thesis on moral hazard. So I had known that for years before this case came. If I may add here, it was not just average Joe and small people who had invested in this Icesafe internet bank. They always offered 1% more interest rate than everybody else. But it was, for instance, Oxbridge, which had invested. It was Scotland Yard, which had invested. It was Gordon Ramsay, the famous former football player and restaurant owner, who at the time I think had 15 Michelin stars and so on. It was speculation going on here, and we felt that both from a legal perspective and from an economic perspective, we had to throw out this case, and that's what we did.
Well, it strikes me as the right thing, especially as a citizen of Belgium, which decided to guarantee Dexia and basically use taxpayers as collateral for what happened to that bank, and of course, Belgian taxpayers had nothing to do with that. So I think that was a wise decision.
Thank you. That was exactly the point. And a lot of people said, well, had the ECJ be competent here, they would have ruled the other way around. It may well be so, but it doesn't change anything about the fact that we did the right thing.
Well, I happen to have met the president of the ECJ, I think, who's still the president, my former professor, Koen Leenaerts, and I basically asked him, but obviously he did not want to comment. But it would be a very tricky situation, I think, for the ECJ. And I can only imagine the political pressure at the time. So well done, I would say.
Thank you.
Okay, well, it was a real pleasure to have this podcast with you, and yes, I look forward to continue to follow you on Twitter, and to stay in touch. So thank you very much.
Thank you very much, Peter. Thank you.
The Brussels Report podcast.